President Trump in South Florida last year was back in court this week, asking a federal judge to let him represent himself as prosecutors tried to block him from introducing irrelevant evidence during trial. Ryan Routh's court-appointed federal public defenders asked to be taken off the case, saying that he had refused repeated attempts to meet with their team. Separately, prosecutors asked a judge ahead of the September trial to rule out the introduction of inadmissible evidence, such as Routh's previous writings that may unfairly influence jurors. The judge said after hearing the arguments that she would issue her decision at a later date. Now, U.S. District Judge Eileen Cannon signing off on Ryan Routh's request to represent himself during trial, but said court-appointed attorneys need to remain as standby counsel. The judge told Routh she believes it's a bad idea for Routh to represent himself, but he wouldn't be dissuaded. Routh, who has described the extent of his education as 2 years of college after earning his GED certificate, told Cannon that he understood the potential challenges and would be ready. Routh had his first chance to represent himself in Cannon's courtroom Friday as she heard a motion from prosecutors to limit evidence of his writings that they say is unrelated to the charges and that he hopes will swing jurors to his side. Now, a bit earlier today, I did have a chance to speak with an expert to break down what all of this means and what to expect. John Day is a criminal defense attorney in New Mexico, joining us now to talk all about this. John, thank you so much for being here with us.
Thanks for having me, Josh.
All right, so the first question I do want to ask you here, we know that Ryan Routh has asked to represent himself, and the federal judge Eileen Cannon allowing that. Can you walk us through the legal standards that judges apply when they're approving self-representation? What factors overall does the court tend to consider?
Right. Actually, the starting place is what Abraham Lincoln said about this. He said, "He who represents himself has a fool for a client." I mean, this never works out well for defendants who want to represent themselves. They're allowed to do it. The Sixth Amendment to the Constitution says you can represent yourself. And the judge, in this case, Judge Cannon, is allowing him to represent himself. There are some guidelines that they have to follow. There's usually a team of standby, in this case, public defenders, although he has fired his former public defenders. But the judge is going to allow this because this is entombed in our Constitution. You're allowed to do this, even if it's the dumbest thing you've ever done. So it's not like representing yourself on a traffic ticket or unpaid parking tickets. It's a serious matter. He's facing life in prison. The judge makes the determination that he is knowingly and intelligently making this decision. She's not ruling on whether it's a smart idea or not, but he will be able to do this. And normally we see this in cases where defendants have an agenda. They want to make a statement. They may know that they're going to get convicted, but they want to go down making a public showing of what their statement is. Not a good idea, but he's going to be allowed to do it.
What safeguards are maybe in place if for some reason the defendant, and not just speaking about Ryan Routh, but cases like this in general, if the defendant does become disruptive, disorganized during the trial, does standby counsel step in at any point? How does that work?
Well, the first thing that happens is the judge will try to shut down any irrelevant activity by the pro se. It's what they call someone who's representing themselves, a pro se defendant. The judges are going to exert some pretty strong controls over that defendant. At the same time, the judges know this is not a trained lawyer. They do have there's a certain amount of leeway that the defendants are going to be given, but they're not going to be allowed to be disruptive. The judge is not going to allow them to disrupt the proceedings. And they will, sometimes they're actually removed from the courtroom if they get too disruptive. In this case, it looks like Routh has a very specific agenda he wants to get out, and he may be able to do that up to a point. But at the end of the day, is it going to benefit him as far as being convicted of these charges that could send him away for life? No, it's a bad idea.
You kind of touched on this already, but how often do you see court-appointed public defenders requesting to withdraw from a case? And what circumstances does that typically happen in?
Yeah, and in this case, these public defenders said, look, the relationship with this client is irretrievably broken. And, you know, if you're a lawyer in a case like that, you're trying everything you can to stay in the case, to work with the client. But of course, some defendants are going to be so unruly and so difficult to control that ethically, the lawyers have no choice but to tell the judge, look, we can't proceed. Now, in this case, and a lot of these cases, the judge will make sure there is standby counsel, the lawyers sitting at the counsel table or in the courtroom to consult with the defendant if he or she needs help. But a lot of these times the defendants don't want help and they refuse to accept it. And so that's why these trials can be so difficult and much longer and more complicated than a normal trial.
One thing that's been making the rounds on social media is that Routh actually submitted a letter requesting to be traded in a prisoner swap with foreign adversaries, a detail that the judge publicly kind of dismissed there. So could a bizarre filing or action like that impact how the court views his fitness to actually stand trial, or maybe his credibility?
Right. Well, the issue of the underlying this, of course, is competence. As a person in this situation, mentally competent to represent himself and to stand trial. That's a different analysis. It goes to things like, psychological evaluation. But if a judge determines that a defendant does not have a competency issue, then it gets into what is a judge going to allow. In this case, for example, his claims about wanting to be traded to a foreign adversary give us some insight into the level of delusion, and the judge is going to take that into account. But this judge is not going to allow him to go into that in the trial because it's irrelevant. It does give us a little window into how he thinks, though.
And from a legal perspective, what may be key developments in the coming weeks or prior to that trial getting underway would signal confidence in the fairness and the integrity of this self-representation, and what might raise some red flags?
Right. Well, they'll be doing a lot of pretrial work in terms of limiting evidence that can come in. Obviously, the prosecution wants to keep this focused. They don't want Routh to be able to go off on these tangents where he gets into his agenda, political agenda, whatever his motive is and whatever message he wants to get out. So I think a lot of this is going to be focused on limiting what can come in. It's going to be a difficult situation for the judge, obviously, because this pro se defendant representing himself is going to be apparently trying to get a lot of material before the court that the court's not going to want to hear. So at the end of the day, he's not going to benefit from representing himself. It never works out. But apparently he has a message he wants to get out, and it's going to be up to the judge to determine how much of that is actually going to show up in court.
All right, John Day, thank you so much for providing that legal analysis, helping us to really understand more about this situation, as we are just maybe about 2 months away from the current date for the trial. Anything else that you want to add here before I let you go?
It's going to be a difficult situation with this defendant trying to get his agenda out before the world. We'll see how much the judge limits that. And at the end of the day, he's making a very bad decision from a legal standpoint and a defense standpoint.
John Day, thank you again for taking the time to join us here. We appreciate it.